Hello, and thank you for your interest in our video. My name is Dorothy Schuldman, and I'm a student attorney with SUNY University at Buffalo School of Law's Civil Rights and Transparency Clinic. This presentation from April 2021 is tailored for journalists and student journalists interested in learning more about New York's Freedom of Information Law, or FOIL. We understand that requesting public records through FOIL can be complicated and confusing. So if you or your organization is interested in a FOIL training to learn how to apply the process to your work, please click the clinic's link below to contact us. The clinic also pursues FOIL litigation, and we would be happy to consider your case. We want to thank our co-host, the Buffalo Association of Black Journalists, and you for watching. All right, well, good evening, everybody. Thank you for joining us today. My name is Dorothy Schuldman, and I am joined here with my colleague Kyle Ruffner. As student attorneys of the Civil Rights and Transparency Clinic, we enjoy holding these trainings to fulfill our mission of the clinic, which is to support access to open records, which promotes transparency and accountability of government. By training journalists, students, and citizen activists in the use of the open records law, we can help you as important stakeholders of the law like you obtain information about the inner workings of our government. Essentially, we provide these services as we understand how complicated the process is, and we want to make your jobs easier. We hope you continue to connect with us, and if we can be of any help in addition to these trainings, we hope you reach out. We litigate FOIL cases, and we'd be happy to consider yours. We also have a do-it-yourself tool for FOIL requests posted on our website. And following this training, we will provide a link to that tool as well as a copy of these slides for your reference. I'm now going to hand things over to my colleague Kyle to start us off with our presentation. And again, that'll be followed by a nice Q&A session at the end.
Thanks, Dorothy. So today we're going to provide an overview of Freedom of Information laws. We'll walk through the process of making a FOIL request. We'll go through some of the best practices and how to correct some common mistakes, and then go through an example of a FOIL request. So FOIL states that the government is the public's business and that the public should have access to government records in accordance with the provisions of this article. So FOIL is a tool that anyone can use in order to get information from the government, and you don't have to give them a reason for it. How it works is you send them a letter electronically, and the agency is supposed to send you the documents that you request. Now, you can't make them create any new records or answer any questions, but you can have any record that is not exempt, and we'll talk more about the exemptions from FOIL later on. So who is subject to FOIL? So any government agency, so the executive branch, are all subject to FOIL. We've included just a few examples on this slide, such as the Department of Labor, the Department of Health, and the MTA, but this also applies to any local government agencies. So governments of counties, cities, towns, villages are all subject to FOIL as well. Now, it does not apply to the judicial branch or private companies or firms. So there are some agencies that operate in the space between public and private. Some of these are subject to FOIL, and then some of them are not. For example, the Water Authority is subject to FOIL, whereas the Metropolitan Museum of Art is not. So even though it receives public support, it has independent governance and is not considered a public agency. So what can you get with a FOIL request? So FOIL provides access to any government records. So that means any information held, filed, or produced by or for an agency or the state legislature. So the important takeaway here is to think expansively about records. A record is anything that an agency has. So some everyday examples include emails, text messages, calendars, phone logs, or metadata. So all of these and many more are all considered records under FOIL.
Thanks. All right, so now what you're seeing here is the FOIL request timeline. And it might look a little complicated, but what we're going to do tonight is break it down step by step. You might be able to see that there's kind of three distinct parts to this. There's the FOIL request, the appeals process, and then there's the last piece in which you can actually sue for records under Article 78 of New York law. So we're going to go through this part by part and break it down for you. So before getting into that, where you want to start is with planning your request. So there are some questions you're going to want to ask yourself. Really, what is the information you want? Is this information already available to the public? Maybe you don't need to go through this process. What records may contain the information you want? Is there a specific format that you're looking for? Perhaps you're looking to analyze data in Excel spreadsheet, so you're going to need to stipulate that in your request. And then what records does this agency have? So essentially, like all of these questions are important as you're making these different considerations in writing your request. All of these questions will help you with the description of the data needed. You're going to want to narrow it down to the dates and time periods. Provide titles if you have them, if you know the name of a certain report that you're looking for, any file designations, anything else that will help the agency staff find the request. So all of these are kind of essential as you're making and writing your request. Really what we're getting at is we want you to be as specific as possible when you're writing your request. So a tip could be find out how an agency keeps the records of your interest. Maybe they log them alphabetically, chronologically, or by location. So really, as many specifics as you can provide will help you facilitate your request and truly even avoid a denial of your request, from being, overly vague, which is kind of the case of what happened here. So we'll get into it later with the different part of the process. But if you're go through the FOIL request process and your appeal is denied, you can actually submit that to the Committee on Open Government, which is within the Department of State, and they're responsible for overseeing and advising on the Freedom of Information law. So they can issue you an advisory opinion on your denial. There's no legal force to this opinion, but it might just be good to know maybe how to fix it or how to move forward. So here in this case, for example, they issued this opinion, and in the advisory opinion, they stated all records pertaining to wind energy and development was too broad of a request. So how would you fix that? So maybe a report name, a date range, or a location of the records. Maybe if you don't know the report name, the categories of the documents, maybe, or that they're emails, memoranda, etc. Any way you can kind of just narrow it down to get the information you need. That will go a long way. And so what we wanted to provide is an example of a website. This is, in this case, the Erie County Water Authority, and what your research might look like when you're looking into an agency to kind of find out what you need to know to make your request. Research goes a long way in this initial part of the process to find out as much as you can on the agency and how they keep their records. So this, for example, is where we would recommend starting with the agency's website. Do they have their own delegated page for FOIL requests, where they'll tell you how to do it and perhaps who to submit it to, like in this case. So we recommend that you do that due diligence and try to narrow your request as best you can to get the information you're looking for.
Okay, so in this section, we're going to go over the possible agency responses to FOIL requests. I'm going to start by going through the rules for how and when an agency has to respond when they receive your request. So when an agency gets a FOIL request, they have to acknowledge receipt and either one, grant access, so provide you with the records that you requested, deny access in writing, along with reasons for the denial, or state that they need more time in writing. So if more than 20 days is needed, they must explain why and provide a deadline. Now we'll go through some of the things that an agency may do to avoid or deny your request. So some of these things may include ignoring your request, charging illegal fees, denying your request, or claiming exemptions. And we'll talk about each of these one at a time. And then for each scenario, we'll go through what the agency may say and then what you can do about it. So what should you do in the event that an agency fails to respond in a timely manner? Or if an agency is ignoring your request or does not meet their deadline for response. So in this case, you should send a follow-up letter with the following information. State that the records you requested and the day you requested them. State that the deadline has passed, 5 days since the request, or the time period given by the agency after acknowledgement when they said they would provide the records. State that you consider the request to have been denied, and then state that FOIL requires a response from the agency within 10 days of the appeal, and if denied, that they must explain the reasons for their denial. So another thing an agency may do is try to charge illegal fees. So which fees are legal and which are not. So some fees that may be associated with your FOIL request include if it takes an agency more than 2 hours to prepare, extract, or generate electronic data, the agency can charge for the employee's time. If you request electronic records that require extensive preparation or programming, the agency can charge the actual cost of reproducing the records. And most records will cost up to 25 cents per copy, but the agency can charge the actual cost of making really large copies. Some things that an agency may not charge for include inspection, certification, or searching for the records. And there's often no basis for charging for electronic records. So as long as the agency has the record in that format already, then you cannot be charged for that record. So what's the best way to get around fees? It's usually to ask for them electronically or just to go look at them yourself, take pictures and make your own copy of the record. So when can an agency deny your request? So agencies are only required to provide documents that they already have. An agency won't be required to do any research or create new records for your request. So an agency may reject a request, though, that does not reasonably describe the records. So if a request is too vague to answer, agencies won't be required to search for a needle in a haystack. An important note, though, is that an agency cannot say that a record isn't reasonably described just because you request a large volume of records. So just because they have to produce a lot of records, that does not mean that you didn't reasonably describe the request. And lastly, a denial of access to these records must be in writing, state the reason for denial, and advise you of your right to appeal. Another common reason for a denial is that an agency may claim an exemption from disclosure. So an agency can deny records if they fall into one of 9 categories. I'll go through 3 of them now that are the most common. An important note for these exemptions, though, is that even if the agency can show that parts of the requested material are exempt, that doesn't mean that the documents are entirely exempt from disclosure. So only portions of the record that are specifically exempted may be withheld by the agency. So the first common exemption is for personal privacy. So limited redaction is allowed to protect against invasion of public or personal privacy, so personally identifiable information. But don't be discouraged by heavily redacted records, and don't automatically assume that a redaction means you won't be able to get that information, because even redactions can still be appealed and often will result in fewer redactions or completely redacted, redaction-free pages. Another common exemption is the inter-agency or intra-agency exemption, which applies to records relating to government decision-making processes. Within this exemption, though, there are still required categories of disclosure. So even if the record is an intra-agency material, so for example, emails exchanged between or within agencies, to the extent that those emails contain facts, information to staff, or final agency policy, all of that information will still be subject to disclosure. The last exemption we'll talk about is documents that are exempt by statute. So common statutes agencies will cite are FERPA or HIPAA. FERPA protects against the privacy of student records, but usually this information can still be de-identified. So with a FOIL request, you should still be able to get like summary statistics. And then with HIPAA, that exemption only applies for healthcare providers.
The next part of the process is the appeals process. So we'll talk to you about what will happen if your initial request is denied. So what do you do next? So this may be words of advice from a FOIA expert, so the federal law, but it still rings true. So we cannot stress this enough. Appeal, appeal, appeal. It's really important, and it just might be the answer to your problems. So an appeal must be made within 30 calendar days of the denial. Where to send your appeal is very important. Oftentimes, the agency will designate a specific person or other department that will handle the appeals process. So please do your research and make sure that you're sending it to the proper place. For example, the NYPD has their own separate appeals department. And then again, there may be instances where it just isn't clear. Perhaps staff can't help you. It's not clear on their website. So what you can do then is send your appeal to the chief executive or governing body of the agency. That's always your best bet if it's too hard to determine or if the information just doesn't exist. And then the agency is required to respond within 10 business days. So yeah, I just want to note the difference there. You have 30 calendar days, but then they have 10 business days to respond. So that's important to understand that difference. Okay, so now we're into the last part of the process in which you can sue for records. So if you've gone through, your initial request is denied, your appeal is denied, then you can go through a lawsuit through use of an Article 78 procedure. And the statute of limitations for this appeal is 4 months. So it's not a lot of time. And agencies know what a great deal of work goes into an appeal. So, if you get to this stage of the process and you need help, feel free to reach out to us. We would happily consider your case. But then again, there are other options. There are other ways in which you might be able to still get your information instead of pursuing this. So I wanted to go through some alternate strategies. What else can you do in addition to a lawsuit? We have a lot of journalists on the call here today. You can name and shame in an article, write a story about how they won't give you the record you're entitled to. You can try negotiating. Can you look to someone else perhaps that might have the data or another higher agency maybe has the data? Perhaps you've done your research and you know that this agency collaborates with another agency. For example, police records police department often collaborates with the DA. Maybe you can get the records from the DA instead of the police. That's another option. And earlier I went through an example of an opinion from the Committee on Open Government. So that's another option to pursue as well. You can request that the Committee on Open Government give you an opinion on whether or not your denial was correct, and they'll give you a pretty detailed answer on what happened and what you could probably do going forward. But again, there's no legal effect to this opinion. It's really just could actually potentially help you with your lawsuit going forward. So it's still a good option to pursue, perhaps either way.
Okay, so here are some key takeaways and general best practices when it comes to making your FOIL requests and following up on them. First key is to always be specific with your requests. Now this includes specificity in describing the records, but also including specific keywords or phrases in your request, such as the name of a particular event that you want information on. Another thing you should do is provide specific date ranges that you are looking for records from. And also, like we talked about earlier, request a specific format, such as electronic records, to try to avoid fees for the request. Since there are strict deadlines for appeals, you also want to make sure you're staying organized. So keep a calendar, keep track of all your deadlines, and that includes following up on requests when you haven't heard back for a while, and always appealing. So here are some do's and don'ts for when you're making a request. So something you should do, like we've talked about, is to always be specific. Now, this is the best way to avoid denial on the basis that the record wasn't reasonably described. So for example, rather than saying, I would like information on town salaries, you should be more specific and say, I would like a record of Village Mayor John's salary from 2010 to the current year. So you're including the village name, the person whose salary you want, and the current and the date range that you want the records from. Another thing you should do is keep a calendar. Make sure you don't miss the 30-day deadline to appeal FOIL requests. Now, missing deadlines, again, provides an easy reason for an agency to deny your requests. So calendar all your deadlines, set reminders, and always remember to file your appeals. Another tip is to follow agency rules for appeals. In particular, what we're talking about here is being sure to find the right contact for the agency when you're making an appeal. So you should keep in mind that some agencies have separate email addresses for FOIL requests and for FOIL appeals. So this is the case, for example, with the NYPD. So make sure you file your appeals to the proper contact within 30 days, or the agency may dismiss the appeal.
Okay. So now we're going to try to take this process and put it all together. What we're going to do next is actually go through an example of a FOIL request that led from a FOIL request to an actual lawsuit for the records. And we're going to kind of break it down part by part, look for best practices, and also try to understand common tactics an agency may use to deny your request or delay your request. So in this action, if the New York Lawyers for the Public Interest pursued records from the New York City Police Department. They were requesting body cam footage and 911 calls after the fatal shooting of a woman suffering a mental health crisis. What the lawyers were looking to understand and what they're looking to compile is that they're trying to essentially demonstrate that police should not be the ones responding to calls involving mentally unwell people, those who are often in crisis, and they rather a trained professional should be the one arriving on the scene as the first responder. So that's what was the purpose of their request. So here it is. So on October 2018, the New York Lawyers for the Public Interest filed a FOIL request for the unedited audio and video files from the body cameras the officers wore during the shooting of Miss Mueller and the 911 audio files. So I kind of want to break it down to you here. We probably sound like broken record, but we keep highlighting that we want you to be specific in your requests. The specificity of the request matters. And I think here the lawyers recognize this. What they had asked for was the unedited audio and video files from the body camera the officers wore. So they didn't just assume that they were going to get one file containing both parts, all laid on top of each other. And then their time period was specific as well, during the time period of the incident. And they also requested the 911 audio files, again, assuming that they weren't just going to get everything all together. So just breaking it down, being extremely specific. Yeah, we can't really recommend that enough as you file your requests. Okay, now we're going to get into the next piece, which is the denial of their initial request. So really what I'm going to walk through here is that it's what happened was likely evidence of the tactics that the agency deploys to delay requests and the denial of the requests. And then I'm going to go through each of the denials and explain to you why a court did not find them, did not allow them to be useful. So 5 months later, the New York City Police Department denied the request, citing several reasons. So 5 months, you might be questioning the timeline that we showed you earlier. That's much longer than an agency is supposed to have to respond. Well, they likely kept pushing it out and delaying it likely on purpose. And then the New York City Police Department only came back to deny. So they cited 5 common exceptions, but when it finally went all the way to the court, at like the last part of the process, the judge kind of dismissed each one. So first, they said that it was an ongoing investigation or judicial proceeding, and that was the reason for the denial. Well, no, actually, what the investigation had been closed, so you cannot claim disclosure would interfere with an ongoing law enforcement investigation if that investigation has concluded. Also, they had, I think, made an argument related to kind of tainting the jury pool here as well. Should there be other judicial proceedings, perhaps against the officers? But the judge did not allow that to go through, that reasoning to proceed either, because such a large jury pool in the city of New York. So that did not stand. So then they had said that releasing this body camera footage would endanger the life or safety of persons, all the people involved in the incident. For example, the EMTs that came on the scene, perhaps their IDs would be released. But here, the judge said that was not a valid reason, that personal privacy would not be compromised. And further, as Kyla mentioned further, there are redactions you could make as well. And here the New York City Police Department did not offer or provide any examples of redactions. So they could not use that excuse either. Another one that they tried to use was that it would interfere with privacy. So ultimately, what the court said was the inherent right of the public to know outweighs privacy concerns, and that further, this wouldn't be an unwarranted invasion of Susan Miller's personal privacy. And again, they had made they didn't say what they were willing to redact, if anything. So that did not work either. Another exception that they tried to cite was inter-agency or intra-agency materials. So here they were not even if they were inter-agency or intra-agency materials, as Kyle had mentioned earlier, you cannot withhold those materials if it contains factual information of what had gone on, which is exactly what these videos would detail. They would just contain the facts and the circumstances of what happened during this incident. And lastly, they also said that they were exempted by state or federal law, but citing HIPAA concerns, but there were no HIPAA concerns here because they are not the type of agency or provider that can claim use of HIPAA. So that did not work either. All right, so then with their denial, there was a little bit of an interesting appeals process I kind of wanted to break down for you as well. So the lawyers timely appealed the police's denial. The Police Records Access Appeal Office, which is their separate office that handles the appeals, denied the appeal. So they tried one of those alternative tactics that we recommended. They tried asking the police department to reconsider its denial, but again, the police denied the lawyer's appeal again. So then, with left with this many denials, their hands were tied, and they knew they needed to pursue a suit for the records, which is exactly what they did. Here, the lawyers in September 2019, they sued the police to compel the release of the records. In June 2020, they got their first order from the trial court, which granted the order and release for records. And then later, the New York City Police Department appealed that ruling. And just recently, in March 2021, the appellate division affirmed the trial court order. So they were, in the end, able to get those records. But you'll likely note, since they filed their first request in October 2018, and they did not receive their opinion allowing them to receive the records until this year, It can be a long process, but it can also be worthwhile, as here the lawyer succeeded. So we know that this could be a daunting process and complicated from what we've just laid out, but public accountability is crucial. Your ability to pry these documents loose and put them in the public eye is essential to our democracy. And just what we wanted to say was, we are here to help you with your work. So this is complicated, but we are here to help you navigate that. So with that, thank you so much. I'm going to show you the resources I had mentioned earlier. And again, you will receive a copy of the slides following this call. And the slides also contain how to contact us in the future. If you ever have any questions, you can contact our attorney, Mike Higgins, who's on this call, with any questions you have. And you'll receive his contact information as well. So